regularly over the past year?
Yes.
Have you been staying in hotels when you visit Texas for the past year?
For the past year, no.
Okay. Have you been renting cars on your visits to Texas?
Yes.
Okay. Do you possess an engagement ring that I purchased for you that has a value over $3,000?
No.
Okay. Did you voluntarily move out of state after the verdict of our jury trial?
I have not been a legal resident living in Texas as my residency since February of 2024.
We were in court
That's
6 to 8 weeks ago. Sorry, this is a question. I get to ask questions. We were in court a matter of weeks ago, and you testified that you had a lease in Texas, and the judgment that was made for our custody agreement was based on the fact that you testified that you had a residence and would continue to have a residence in the state of Texas. When did your lease expire in Texas?
my lease expired in Texas in 2024.
You testified 6 weeks ago that you actively had a lease. I've seen you at your home literally weeks ago in Texas where you still had a lease.
I did not have a legal binding lease in Texas after it had expired in 2024. I was in the house that I was using for visitation when I was in Texas. That was not on a secured lease. That was somewhere that the landlord, after the lease expired, allowed me to remain until I gave notice that I would no longer be using the residence during my visitation time in Texas.
Okay, I'll clarify the question. Did you have a month-to-month lease in Texas up until recently?
I did not have a legally binding month-to-month lease in Texas.
Your Honor, what's the objection for somebody like clearly lying about a question? I don't know what.
Um, so again, I'm not able to provide either party with legal advice. I can only say that if um, you will have the opportunity to testify after her testimony is concluded. So you can tell me, it sounds like you contend that she is not being honest with the court. And if that is so, you can tell me when you testify why you believe that to be so and what evidence you think supports that contention. But
Okay,
for now, keep it to question and answer, please.
okay, I think I've asked all the questions that I need to ask related to her finances for now.
Okay, great. Thank you. All right, Ms. Glennie, anything else to clear up?
Yes, I do not own my car, and my monthly payments are variable as stated. And I have not been a legal resident of Texas, and I never became a legal resident of Texas. And the lease that I had in Texas was for the year period that ended in exactly May of 2024, and the lease was not renewed. I never testified under oath to anything that stated that I was a resident of Texas at any point in time. Thank you.
Okay. I do have a question for you, Ms. Glennie. Um, so the documentation, the sworn statement of inability to afford payment of court cost and an appeal bond, which you filed on September 9th, 2025. Um, the take home pay that you indicated on this document was $6,329.12. Is
That
that
is
correct?
that is gross, Your Honor. That is correct. Wait, no, 6,000. No.
Well, I'm just reading from your form. So this is page 6 of 13,
Sorry.
the document that you filled out and swore to.
Mhm.
Number 5, what are your monthly income sources? And the answer, my take-home pay is $6,329.12 in monthly wages.
No, that was just a calculation error. It's not on every proposed support decision I've ever submitted in all of my payroll documents before the court. My gross wages are $7,083.34 after the deductions, which account for $1,179.22. My take home net is $5,904.12. And so number 5 on page 6 of P003 is a error.
Okay. And so tell me, so what is your gross annual salary at your current job?
My gross annual salary is 85,000, I believe, and that comes out monthly as 7,083.34. Let me just look at my pay stubs. They say it in the pay stub.
Okay. And you attached those. Did you attach those?
Yes, that's in P007.
Okay.
So
Remind me, what's the name of your employer?
standard crypto.
Okay. And do you get any bonuses from them or other income besides the annual salary?
That's variable. I am actually not suspended, but I am on a probationary period currently right now with the company.
Okay. What does that mean?
I made several errors, and now due to performance based, my job is at jeopardy.
Okay. Are you on a performance improvement program
Yeah, basically, yes. That's
or plan?
I'm on notice.
Okay. So, and how long have you been with this company?
I have only been with the company for about and since last April.
And how many bonuses have you gotten so far?
One bonus from last year for the
And
20.
what was that?
It was like $1,200.
Okay. And any other forms of income?
No, Your Honor.
And you're not working any extra jobs?
No. If like occasionally like I could do if somebody has like an event or something, I could be called to do the event, but I haven't done that and I don't have time to really do them, so no.
Okay. And your son that lives with you, he lives with you full time?
Yes, Your Honor.
And do you receive any child support from his father?
No,
Okay. Are there any court orders related to your son?
no.
Okay. And why isn't his father paying child support?
Because his father has never been court ordered to pay child support, and even if he were to pay child support, he would never pay it.
Okay. All right. Let me see if I have anything else for you. Okay. All right, Mr. Epperson, did my questions cause you to have any follow-up questions?
Not at this time.
Okay. All right, then I guess that completes Ms. Glenny's testimony, and Mr. Epperson now would be your opportunity to tell the court whatever you want me to know and understand about Ms. Glenny's financial situation as it regards to her indigency application. Excuse me.
Um, I think in the questioning we've covered plenty. She has a $50,000 vehicle with a $500 to $700 a month payment. She's chosen to pay for two houses over the course of multiple years. She does have assets, including the ring that I purchased for her. The Volvo is in her name. She could sell that Volvo. She has literally been flying in like premium class back and forth on American Airlines flights with sometimes by herself, sometimes with two children to travel back and forth between Nevada and Texas. And she's been doing that for at least 6 or 7 months. Miss Glenny chose to move out of the state of Texas. She chose to maintain multiple households with multiple rent for a long period of time. Like I just don't understand how she can claim to be indigent or sorry, I don't know what the word is. I don't understand how she can claim to be broke if with the information that she's just admitted to in this proceeding. Also, I'd like to add that Miss Glenny is the one who's appealing a case that was just settled a matter of weeks ago. So her claiming to not be able to afford an appeals process when she clearly has financial means and is spending at a reckless rate doesn't make sense to me. I don't understand how she's asking the court to waive court cost for a thing that she's initiating. We went through a very lengthy, expensive, time-consuming jury trial that Miss Glenny demanded. The court, my attorneys, and myself all asked her very politely many, many times to not put us through a situation that was going to be that expensive and time-consuming. I just don't see that there's any justification for the appeal in general. I know that's not what we're discussing here today technically, but not wanting to pay for an appeal that she's initiating of a case that was literally just settled doesn't make any sense. The only reason she's filing for an appeal is, I mean, from my understanding, I'm not an attorney, so I appreciate your patience. Appeals, from my understanding, are based on the grounds of like legality, not disagreeing with the judgment. So there has in fact been a jury trial and a bench trial combined to create the new Texas custody order. There were no legal issues with that case. It was all handled properly. Miss Glenny just is throwing a temper tantrum because she doesn't like the outcome of the of trial and she's intending to appeal this like for that reason. I don't have the capacity or the time or the emotional ability or the finances to be able to go through an appeal process when we just finished a trial weeks ago. So, um, I asked the court hold Miss Glenny accountable for filing for these appeal proceedings, and I believe that she's, per her own testimony, admitted across many different, variables that we've talked about that she can in fact afford this. She just doesn't want to pay for it.
Okay, understood. And you mentioned the airline flights. I guess, well, why don't you tell me a little bit more information? Like, how are you saying she was flying first class with the kids or business class? And I
I,
guess, tell me what you know about that.
yeah, I can't speak to the specifics of each flight, but I know that I understand because Miss Glenny lived with me for multiple years what her, like in her testimony, her self-proclaimed
Objection,
life's.
speculation,
I didn't hear the objection. I'm sorry.
speculation. It
Overruled.
assumes facts, not in evidence.
Overruled. You may continue.
Miss Glenny, in her own testimony, literally minutes ago, claimed that she has grown accustomed to a certain lifestyle, a high spending lifestyle, and that's evidenced in having multiple residences. She has personally flown with me first class many times. I know from personal experience and seeing past flight tickets that she does like to travel frequently. She travels frequently for the sake of the kids and also frequently for vacations and her own personal reasons. So somebody who claims to have zero net worth and claims to be broke would not fly repeatedly and have multiple homes. It just doesn't make common sense.
Okay. And have you you heard my questions to Miss Glenny about the statement that she filled out? She did not mark Medicaid. Do you have any information one way or the other about whether your daughter, Octavia, is on Medicaid?
My daughter receives no benefits related to Medicaid, Medicare, food stamps, reduced lunches. None of those things exist.
Okay,
Excuse me. Can I add something to that?
go ahead.
Unless Miss Glenny is claiming those benefits, keeping that for herself, and it's not being used for Octavia, which I wouldn't know.
Understood. And as far as free or reduced school lunches, where is your child attending school?
She's in Cunningham Elementary, which has all students, regardless of income, receive free breakfast and lunch there.
Okay. All right. And I think you testified earlier about she's supposed to be on whose insurance?
The court order states um, that Octavia is supposed to have her health insurance covered by Miss Glenny's employer. Currently, I am paying $704 a month for my health insurance and Octavia's health insurance because I don't get health insurance through an employer. So obviously that $704 is not all for me or all for her, but if you a couple $100 per month, I'm paying out of pocket right now because Miss Glenny has refused to enroll her in the free health insurance that she has available through her employer. And that's been ongoing for multiple months. So it's literally cost me, I don't know, over $1,200. I'm not sure exactly. Sorry, I don't want to go on record saying the wrong number, but it's cost me hundreds and hundreds of dollars to pay for health insurance because she's refused to follow the court order.
Okay. All right. And at the time that you and Miss Glenny were together, you believe that the Volvo was owned outright by her?
While Miss Glenny and I were living together and raising the two children together, she, against my advice, went out and bought a $65,000 luxury Volvo. And her name is on that Volvo, always has been on that Volvo. It is not a lease. I've seen the documentation. I've argued with her about buying an expensive vehicle she couldn't afford. So there is no lease. She perjured herself in in that aspect of her testimony. But I know that for a fact.
Okay. All right. I don't have any other questions. Do you have any other testimony to offer before you pass yourself as a witness?
No.
Okay. Ms. Glenny, do you have any questions for Mr. Epperson?
Yes. What evidence, if any, do you have that I purchased premium airline tickets?
The only information that I have is verbal and text communication from you about purchasing tickets for you, Octavia, and Aiden to fly back and forth between two states over the course of however long it's been.
But what is the evidence that these purchases that have allegedly been made are premium airline tickets that would be seats in first class or business class?
I have asked repeatedly for travel information about Miss Glenny and both of the children, Aiden of whom I raised and fully paid for his entire life for up to 5 years. Miss Glenny refuses to give information about
That's
the
been not
whereabouts of
responsive.
I'll overrule. You may complete
Miss
the answer.
Miss Glenny has repeatedly refused any information about airline travel, the whereabouts of both children, including Octavia, up to and including taking them out of state illegally Octavia, taking Octavia illegally out of state against a court order just last week. So she purchased airplane tickets, took Octavia out of school, took her to Nevada, had her miss over a week of school so she could have a vacation in Nevada, which is also a violation of the court order. So it was not necessary for Miss Glennie is claiming she doesn't have money, but it was not necessary for her to fly to Texas, get Octavia, fly to take her on a vacation, fly back to Texas, fly back to Nevada. That's all happened in the last week, and it's also been a violation of the custody order that she's taken her out of state illegally. She hid her whereabouts. She hid an ability for me to be able to communicate and know her whereabouts, and she forced her to miss over a week of school.
Okay.
Mr. Epperson, the Capital One car loan that I have for the financed vehicle, um, or sorry, I'll take that back, strike that. What evidence, if any, do you have that the financed Volvo was purchased for a value worth of $65,000, as you just stated?
I don't have any evidence right now, Your Honor. I didn't even understand what the purpose of this call was today. So I didn't compile anything. I don't have the ability to get additional documentation right now, so I don't be able to speak to these things.
Um, what evidence, if any, do you have that I have taken extravagant trips?
I don't know how to answer that. I don't have evidence. I just have personal testimony from you in the past, documents from OFW, your personal calls that you've made to me about traveling overseas, the fact that you've gone on vacations and asked me to watch not only Octavia, but also Aiden has happened in the last couple months. So do I have a piece of paper in front of me right now that I can upload into Zoom? No, but absolutely those things have happened, and that's just a matter of fact.
When was the last vacation that you claim I have taken?
I don't remember the dates, but uh, sorry, let me think about how to explain this. Your Honor, I don't recall the dates, but Miss Glennie dropped off Octavia for her standard visitation, and she left Aiden Glennie, who's the son that I raised but no longer have an ability to have visitation with. She left him on my doorstep, and basically I had to care for him for 8 to 9 days because Miss Glennie wanted to go on a vacation, so she left both kids with me.
And when
Mr.
was,
Epperson,
can
what
you,
are the dates? Sorry, Your Honor.
that's okay, go ahead.
What dates are you alleging that this occurred?
I'll have to look in OFW and see what the communication is. I don't recall the exact dates.
And what evidence, if any, do you have that I was out of town?
Well, you specifically communicated with me that I needed to watch both children so you could go on a trip. I wouldn't have
But you
any reason to doubt what you said was true at the time when you abandoned your son at my house and made me watch him for 9 days.
but you don't recall these dates, you don't recall the trip, and you don't know where I went.
I don't think there's a burden on me to have to testify to your exact whereabouts. I'm testifying to the fact that you dropped your son off at my house. I had to watch him and pay for him for 9 days so you could go on a trip. That's what I know.
Mr. Epperson, did the court jurisdictionally restrict Octavia during the proceedings from being taken out of the state of Texas?
Correct.
did that require me to during that time, was I required to exercise visitation with her in the state of Texas?
The question is she required, are you required to exercise visitation in Texas? And the answer is yes, that is the order.
And so I exercised that visitation with Octavia in Texas, correct?
Well, recently you have failed to exercise your visitation, have refused to communicate about when you're going to exercise your visitation, and you've also violated the court order by extending your visitation days past what was legal. So no, it has been an entire nightmare of not knowing when you're going to show up, when you're going to pick her up from school. You violated the visitation dates 6 times in the last
Objection,
5 months.
non-responsive.
Overruled.
Your Honor, Miss Glennie has violated the visitation dates 6 times in 2025. She has also failed to execute, or excuse me, failed to exercise her visitation multiple times without communication, causing me to scramble.
Objection. These are all statements that have no validity or have anything in record that have been proven as fact, and they have nothing to do with what's before the court today. If Mr. Epperson wants to seek an enforcement, then he needs to seek an enforcement hearing. This is not an enforcement hearing before the court today.
Okay, if that is a relevant objection, I'll sustain. Here today, the only purpose is to hear the indigency application, Mr. Epperson. So I think what Ms. Glennie pointed out is accurate. If what you're telling me about problems with the court orders and problems with a lack of compliance, if that's what's going on, then yes, that would be for another day for a motion to enforce that would have to be filed, set for a hearing, and notice sent. So we'll set that aside and just concentrate on the issues as it relates to indigency for today. Okay.
Okay.
All right. Any further questions for this witness, Ms. Glennie?
No, Your Honor.
Okay. Anything else that you want to tell the court, Mr. Epperson?
No.
Okay. All right, then I think that takes us to the end. And Ms. Epperson, if you would like to give a brief closing statement that just summarizes what you're asking the court to do and what evidence you think there is in the record that supports that, you may proceed. And then Mr. Epperson, you'll have an opportunity to give one as well.
I'm Mrs. Whitney, who's never married to.
Oh,
Sharon.
I'm sorry. Did I?
Yeah.
I'm sorry if I misstated. Ms. Glennie,
Thank you.
it has been a long week and it's Friday. Go ahead.
No worries. Your Honor, this is, as you stated, about the statement of inability to afford payment of the court cost. And it's very clear, just because I have a job does not mean I have the ability to afford court costs. I've submitted my utility bills. I've submitted all of my documentation. I have submitted to the court my pay stubs. I have submitted to the court my checking accounts statements, as well as my savings account statements. And I have maintained full transparency with the court. There is no evidence whatsoever that I have any ability to pay for the court costs, which I do not. In my bank statements, you can very clearly see how the money is spent and where it goes, and it is not frivolous. It's for the bare minimum of my of taking care of my children. I did not willingly choose to live in two places, and I do not fly extravagantly, and I have not personally traveled in over 2 years. And anything that has been brought forth to, or any allegations that have been brought forth are not substantiated by any evidence other than Mr. Epperson claiming them to be true. Um, I believe the result is straightforward that I respectfully ask that the court does allow me to receive the clerks and and the reporter's records without prepayment so I can pursue my appeal on the merits. The personal data and financial information I have filed is in the record before the court today for this hearing, but as well as if the court chooses to go back through the record of the entirety of this case, I have overly submitted financials throughout it that do not show any deviation from what I have been consistently saying and discussing throughout the entirety of this case. I have a negative net worth. Like my debt is very clear and very substantiated that I owe over $155,000 in debt. I do not own my vehicle. My vehicle is leased, and that lease is with Capital One Banking, and that is before the court, and the court has that. I have no liquid assets. And the monthly deficit I have is very real, as demonstrated in those bank statements where it shows that my account goes into the negative. It shows that I have returned payments that get bounced, and those are not things that can be fabricated. Those are really real things that happen. The court has the past due balances and the past due invoices from different utility companies and different things, and I pay everything as I can. It is not a luxury or a choice for me to willingly choose to live in Nevada. I am from Nevada. My son is from Nevada. My daughter is from Nevada. Um, it is not like it's a luxury for me to go to Texas. Like my daughter, I believe, should be here, and to be forced to exercise visitation there is extremely costly. And I don't know when I return my daughter when the next time I'm going to see her, because I don't know if I can financially afford to see her, which is why this appeal is so important, because I believe that that should be changed. The $65,000 judgment at issue, like I said, is an attorney's fees only, not compensatory damages. I believe from my understanding that under Texas law, fees are not included in the supersedis calculation. And if the court nevertheless considers security, my financial situation establishes substantial economic hardship, and I am asking that the appropriate relief would be to eliminate the bond and to set it to zero, or approve an alternative security consistent with my negative net worth. Accordingly, I am respectfully asking the court to enter orders that recognize my indignancy and directing preparation of the clerks and reporter records without prepayment, and eliminating the supersedis requirement, or as I stated at most, the alternative security. Thank you, Your Honor.
All right. Mr. Epperson, you may give any final remarks that you would like to at this time.
Okay, thank you. Miss Glenny, per her own testimony, has perjured herself repeatedly in the past hour and a half. Um, she chose to permanently move out of state. She chose to maintain multiple households. She did, in fact, have a lease up until recently and has chose financially to have multiple homes and fly back and forth. Um, I don't see how the financial irresponsibility of Miss Glenny is like the responsibility of the court to waive standard fees and for, appeals and documentation. Miss Glenny has chosen to pursue an appeal weeks after getting a Texas court order. There's no grounds for the appeal. The appeal is purely based on Miss Glenny's emotional state. It has nothing to do with the best interest of Octavia. Miss Glenny has moved out of state, leaving me with all of the living expenses for Octavia. I am now raising her full time outside of Miss Glenny having shown up unannounced to the school, creating a scene in which the police had to show up. Then she took Octavia out of state illegally against a court order. She paid for the flights to illegally take her out of state to fly her to Nevada, back to Texas. So claiming to not have any income, well, excuse me, sorry, let me restate that. Claiming to be indigent when she makes $85,000 a year, plus is misrepresenting her secondary job in the restaurant industry, plus the fact that for half of 2025, Miss Glenny received $1,969 from me every month. There's just no justification for her claiming to be poor, and there's no justification for her to want to waive standard court fees and standard appeal fees when this is a completely unnecessary situation that Mrs. Glenny has put us in. That's all I have to say.
Okay, thank you. All right, anything else, Miss Glenny?
Your Honor, just for the record, I asked the court to consider facts and evidence based off of the documents and not statements that have been made without any substantiated evidence that may or may not be circumstantial.
All right, thank you both for your time here in the virtual courtroom this morning. I am going to take these matters under advisement, and you will probably get a ruling from the courts sometime next week. As soon as a decision has been made, you will hear from my staff.
Thank you, Your Honor.
All right. Thank you both. You are free to go.
Thank you.
Thanks.
Take care.